Okay, I think we will go ahead and get started. Hello, everyone, and welcome. Thank you for joining us for today's panel. What can the psychedelics industry learn from cannabis regulation? I'm Mason Marks, a law professor at Florida State University and the senior fellow and project lead of the Project on Psychedelics Law and Regulation, or POPLAR, at the Petrie-Flom Center at Harvard Law School. The Petrie-Flom Center is delighted to bring you this event with generous support from the SciSay Foundation, Tim Ferriss, and Matt Mullenweg. And before we get into this discussion, just a few quick housekeeping items. We welcome audience questions for our panelists, so please do submit your questions, but do so only through the Zoom Q&A function. If you scroll towards the bottom of your Zoom window, you'll see a little button marked Q&A. Just use that to type your questions, and I'll be checking that frequently. You're also welcome to comment or submit questions on Twitter using the hashtag #Poplar, so hashtag POPLAR. If you do submit a question there, Petrie-Flom staff will be monitoring that, and they will pull your questions into the Zoom Q&A. We won't be using the chat function on Zoom or the raise your hand feature, so don't use those options, do use the Zoom Q&A function. If you're interested in other topics in health policy, bioethics, or biotechnology, we encourage you to sign up for the Petrie-Flom Center newsletter, to read our blog, The Bill of Health, which features cutting-edge commentary by legal scholars. I want to thank some of the Petrie-Flom staff, including Chloe Reichel and Laura Chong. And with that, we will launch into our event, What Can the Psychedelics Industry Learn from Cannabis Regulation? So I want to start with just a little bit of background. We are really watching some historic events unfold before us. On Tuesday, Colorado voters approved Proposition 122, the Natural Medicine Health Act, which will create a regulated system for administering the psychedelic substance psilocybin. Proposition 122 also immediately reduced criminal penalties associated with a handful of psychedelics, including ibogaine, mescaline, DMT, psilocybin, and psilocin. Those substances are now decriminalized. In Colorado, people can produce, possess, and even share them. And the regulated system will be created over the next couple years. 2 years ago, Oregon voters passed Measure 109, the Oregon Psilocybin Services Act, which will create a similar regulated market for the supported adult use of psilocybin, and that industry will open for business sometime next year. The Oregon Health Authority, which is the agency overseeing that new psilocybin industry, is now finalizing rules for the Oregon psilocybin market. Those rules will be published by the end of the year, and the public can now comment on them in writing or during organized listening sessions next week. There are about a dozen other states that proposed or implemented related psychedelics legislation that takes many different forms. Some is more medical, some is focused on research, and some legislation might best be characterized as recreational or adult use. And there are over a dozen US cities that have decriminalized psychedelics or deprioritized the enforcement of criminal penalties. So with all of these interesting developments, it's a worthwhile question: what can psychedelics law and the emerging psychedelics industry learn from decades of cannabis regulation? And to answer that question, we've assembled a panel of experts on many facets of both the psychedelics industry and the marijuana industry. And so I will now invite each panelist to introduce themselves and provide some introductory remarks. And I'll go in alphabetical order, starting with Hadass. So Hadass, welcome, and thank you so much for joining us.
Thank you, Mason, for inviting me and for moderating, and thanks to Poplar for having me and having this conversation. So my name is Hadass Alterman, and a few years ago, I founded Plant Medicine Law Group, which is a law firm that works with psychedelic infrastructure companies as well as cannabis companies. I'm the board chair of the Legalization and Regulation Subcommittee of the Psychedelic Bar Association, which Mason and Ariel are both a part of. And I sit on the Equity Subcommittee of the Oregon Psilocybin Advisory Board. And more recently, I'm the incoming director of state initiatives of the American Psychedelic Practitioners Association. So I think a lot about how practitioner issues are going to factor heavily into the psychedelic law and policy landscape in general, and as compared to cannabis. Michael Pollan has said that even if the FDA even if MDMA and psilocybin over the course of the next 10 years are approved by the FDA, nothing else, and only for PTSD and treatment-resistant depression, just those two indications, we're going to need an additional 100,000 trained psychotherapists in the United States. We're going to have to double the number of therapists in the US today just to accommodate for these two indications. That's an entire universe of legal needs, corporate practice of medicine considerations, interactions with state agencies, federal agencies, and this is to say nothing of MDs and non-therapist practitioners who'll be facilitating sessions under supported adult use frameworks. So for me, one of the biggest points of departure from cannabis is this practitioner universe. And at the same time, I think that there's still a lot of valuable lessons that we can draw from things like DOJ's response to Prop 15 and how we'll require that practitioners with psychedelics prepare and educate patients and how we culturally, socially, politically, safely integrate these drugs into mainstream health and wellness in this country.
Thank you, Hadass. We'll move next to Ariel Clark. Welcome.
Thank you so much. And Mason, I want to thank Poplar, and I also want to thank you, Mason, for your just really continued and amazing leadership and thoughts around psychedelics and the ecosystem. And it's just such a pleasure to work with you, and so nice to see everybody here. This is really such an important conversation. You know, I'm so glad, Mason, you started out with sort of the historical moment that we're in, where Oregon is at, where Colorado is at. Laws are changing quickly. And, you know, I started my work in cannabis law reform in 2005 in the Bay Area. And I was involved in all sorts of organizations. I founded and ran the LA Cannabis Task Force and worked heavily on regulations on a local level. I worked with the California Growers Association on the policy committee, all other sorts of drug policy reform work, and a lot of work in cannabis over the years. So I just frame that because I really have seen from very lived experience for a long time what it looks like when cannabis went through the twin engines of government and markets, okay? And what outcomes did we see? And I really think about that a lot because it's been deeply concerning. On the other side, we see consolidation. On the other side, we see legacy markets not able to, I mean, I have clients and friends who are farmers who are no longer involved in cannabis at all. People can't afford the regulated cannabis. Most of the cannabis market in California is not in the regulated market because regulations and taxes are too high. I mean, literally this conversation, I could go on and on about what the issues have been with cannabis, what we need to learn in the psychedelics ecosystem. So I really come from that place of like experience of something really that is a plant and that has healing capabilities, that is something that's opportunities for us as a society to create relationships with, you know, whether that's business relationships, healthcare relationships, and then going through these systems in these kind of very important moments. And how do we not create the same sort of bad outcomes that we see with cannabis? And I will just say, you know, I actually I think about this so much that at this point I am thinking very out of the box. I'm curious about, you know, very broad decriminalization. We need to incorporate religious and community use. We need to have very minimal regulation and taxation. The cost of these medicines it needs to be truly accessible. This is a whole involved issue. Otherwise, this psychedelics will look just like, you know, what we see in the pharmaceutical industry and in this country, where healthcare and medicine is really just affordable for some. And that's the case with ketamine clinics in this country. I looked for a ketamine clinic. I got quoted $2,000, $4,000 for a session. Okay. So it's just really, it's kind of this meta conversation of what are these systems in this country that aren't working? And maybe we need to really kind of turn that on its head. So is it government run psychedelic companies? Is it truly nonprofit companies? I mean, I'm interested in these conversations to really think hugely outside of the box. Otherwise, we will, you know, replicate the systems that we have, and it will go through those twin engines, and we'll see similar outcomes.
Thank you. We'll move next to Professor Robert Mikos. Welcome.
Thank you for having me, Mason. I am Rob Mikos. I'm a law professor at Vanderbilt University. I've spent really the bulk of my career, probably the last 15 years or so, kind of researching and writing and advising about cannabis law reform, and especially the federalism issues that are spawned by this conflict between state and federal cannabis laws. So maybe not surprisingly, the thing that's on my mind right now is really, how's the federal government, how's the DOJ in particular, how will it respond to these new state psychedelic law reforms, like Oregon's 109 and Prop 122 that was just passed? I think the answer to that question will really determine what the psychedelics industry, the regulated psychedelics industry, is going to look like. And for that matter, whether there even is such an industry in the short term. It's important to recall, you know, now we have such industries for cannabis, well-regulated ones in a lot of states, maybe not California, but in a lot of other states. But we didn't have that in the early days with cannabis law reforms, in large part because there was a concern about a federal crackdown. If you start to regulate an industry, you really expose it to federal regulators. They can take that information states have gathered, try to use it to crack down on the industry. So what a lot of states did in those early days when there was still federal hostility is they relied more on personal cultivation of cannabis. And it wasn't until 2008, 2009 with the Ogden memo, the famous first DOJ non-enforcement memo, the state started to come around and say, let's create a commercial market for this. Let's heavily regulate the cannabis market. Interestingly, Colorado's Prop 122, it does both of those things. It authorizes personal cultivation, but also authorizes the eventual creation of a regulated industry. I think how the federal government responds to this will determine whether both of those are viable, or whether Colorado and other states that follow suit have to rely, at least in the short term, entirely on sort of personal cultivation and social sharing. So the federal government's response to this, that's the big issue that's on my mind.
Thank you so much. And we will move next to Vincent Slawski. Vince, welcome.
Yeah, hey, thanks. Hi, everybody. I'm Vince Slawski. I'm a lawyer and the managing partner at the Harris Bricken Law Firm. I'm based in Portland, Oregon. Although I'm talking to you today from New York City, we have an office here too. My background as an attorney is in business and commercial real estate work. I'm exclusively on the transactional or deal side, and I'm helping a lot of people put together little psilocybin companies right now for OHA licensure. I also edit and publish my law firm's Canna Law blog and Psychedelics Law blog. Those are two serials that publish almost every day, and they're really good resources for people interested in this subject matter. I've been lawyering since 2010 and working with cannabis clients for most of my career here in Oregon. I started really thinking and writing about psychedelics in 2018. I recall when Compass Pathways received breakthrough therapy designation at the time from FDA for its synthetic psilocybin drug and treatment protocol. And I basically followed all things psychedelics and law related from that time, and then through the drafting and implementation of Measure 109 in Oregon, which legalized supported adult use for psilocybin. Lastly, I taught one of the first law school courses in the country on cannabis law and policy. I did that for 4 or 5 years. That was at Lewis and Clark Law School in Portland starting in 2017. And we did units on psychedelics and other controlled substances the last few years. I still get to go back once a year for a guest lecture. I like that. So I guess that's to say that in addition to the actual practice of law on behalf of these businesses, I enjoy thinking and talking about these concepts in the space as well. If I were to pick just one concept that's a large distinguisher for me between cannabis and psychedelics regulation, it's probably the 2-track system we have with psychedelics at the state legalization and decrim level on the one hand, and then the FDA drug approvals on the other hand. In the early days of cannabis, there was a lot of scuttlebutt and fear around big pharma and patents, particularly with respect to their effect on local cannabis markets. That generally hasn't had the effects people initially feared, at least to date. With psychedelics, I think we're going to have that 2-track system as well, but it's going to be a lot more prominent on the federal side. That's not to say it will necessarily interfere with state markets, but it's just going to be a far bigger focus with respect to psychedelics legalization, generally speaking. So those are my thoughts. I'm glad to be invited to join the panel. Thanks to Harvard Law and Poplar for having me, and thanks to everybody who's in attendance for joining the conversation.
Thanks again, everyone. So to start things off, I want to see if we can identify some of the shortcomings of cannabis regulation. So what are some of the things that cannabis may have done really well or maybe not so well, and how might that be applied to the psychedelics law and regulation that we're seeing?
There are a lot of them. I could pick a really obvious one, and it's social equity. In the early days of cannabis regulation, the first states that came on board, Washington and Colorado, didn't have anything around social equity in their programs. I mean, it wasn't as much in the air just generally in the zeitgeist as it is today, but those programs just didn't think about, people who weren't as well funded or well capitalized and who'd suffer the effects of the war on drugs. And those programs didn't promote those people at the onset of the programs. And I think you really see the effects of that, because what happens, and it happened here in Oregon too, which came online just a year or two later. What happens is industry gets out, gets going, people start these businesses, they get a head start, they start to get funded, and then maybe the state says, oh wait, maybe we should have some social equity components, and they try, but it's almost too late, the ship has sailed type of thing, or they never even get there, as in the case of Washington. That's kind of embarrassing for Washington. They've been around since 2014 and they still don't have any social equity, anything in that state. So I think, with psychedelics, it's really on the vanguard of the conversations that I've seen, as it is currently for new states coming online with cannabis. That's one big thing I'd offer.
Hadass, I wonder if I can turn to you, because you serve on the Health Equity Subcommittee of the Oregon Psilocybin Advisory Board. How have some of these issues come up in discussions on that subcommittee, and what might be implemented in Oregon with respect to social equity?
Sure. So I have a little bit of a spicy take on this. It's something we do talk a lot about on the equity subcommittee. And I think that part of where things get lost in all of the data from cannabis and the emotion and the conflicting views when it comes to equity here in psychedelics is the gap in understanding about where exactly the mandate for social equity in psychedelics comes from. In cannabis, it's clear. Social equity initiatives are war on drugs reparations, and they are necessary. You can draw a straight line from one to the other. A person's dad was incarcerated for their entire life because he sold weed. The family was gutted, left with nothing. So now that it's legal, that person should have a first shot at a license for sure. You dealt with mass incarceration for selling drugs illegally. Now you got a shot at owning a business where you can sell drugs legally. For psychedelics, it's different. The history of psychedelic prohibition is mass incarceration adjacent, but it's hardly the central narrative. The cannabis business as reparations argument just doesn't align when applied here. And I actually think that it's somewhat ahistorical and intellectually dishonest to use the tragedy that is mass incarceration as a rhetorical and political tool for legalizing psychedelics, which is why, you know, I'm glad 109 campaign in Oregon didn't do it. I'm glad 122 in Colorado didn't do it. And I think, you know, more tangibly, and this isn't to say that ownership does not matter. Who owns psychedelic licensed businesses does matter. But I think that people make a mistake in psychedelics and placing all of our hopes on the idea that the best equity outcomes we can offer people will come from playing with the levers of who owns these state licensed businesses, because among other things, these businesses aren't going to be making a lot of money for the foreseeable future. And we know that because serious capital, for the most part, is disinterested in investing in them. They're difficult to scale. The margins are unsustainable in large part because of 280E, and they're cash businesses. So they'll never 10X, they'll never 100X. And I think in many ways, it's not a financial reward, it's a financial risk. But here is what social equity does look like in psychedelics. At the most basic level, we need consistent, safe, high quality care across the board. We need certified practitioners who are operating at or above a uniform standard of care, who have been trained rigorously to do this work, who aren't going to mishandle clients or patients. We need practitioners who can actually help their clients. And that's a balancing act. That will be a balancing act between protecting consumers and not over-regulating. But beyond that, for social equity in psychedelics, we need culturally competent care for race-based trauma. And I'm going to just say that again. We need, for social equity in cannabis, culturally competent care for race-based trauma. My colleague, Dr. Darren Smith, who's an ethics professor at the University of Memphis, is researching psychedelics for race-based trauma, which he defines as a type of exposure to persistent, dehumanizing treatment, discriminatory behavior, and or racial violence that members of stigmatized minority groups experience. And Dr. Smith goes on to say that persistent exposure to race-based stressors can increase the risk of substance use disorders, which can lead to comorbidities like heart disease and diabetes. The never-ending fear of racial mistreatment keeps a person's body in fight or flight, which causes dysregulation and chronic stress. And the compounding effects of racial discrimination over time result in an increased risk of PTSD. So yeah, I agree with Dr. Smith when he says that we have an ethical responsibility for providing psychedelic assisted therapy within a culturally competent provider framework, and that psychedelic researchers need to recruit and retain BIPOC populations in research and clinical training. Culturally relevant care is social equity in psychedelics. And to touch on something that Ariel, you said earlier, we need to figure out how to make this affordable, which is like a conversation for a whole different panel. But for now, I'll just say that within the medical model, we need to make sure we get standards of care adopted so we can start working towards insurance coverage. And we need to get group therapy insured, because that's really the only workable model from a cost perspective. One-to-one therapy, out of pocket, in person, fee for service is cost prohibitive for most people, and it's not going to result in social equity, and it's not going to result in health equity. But therapy, some form of guidance, whether directive or not, is really important to make sure that these drugs are going to work. And lastly, I think we need to allocate resources for dealing with the stigma around psychedelics that's been created by the war on drugs, as well as stigma about talking about mental health issues in BIPOC communities.
One thing that was mentioned, I think, Ariel, you mentioned consolidation and how that has been a concern in the cannabis industry. I wonder if you or anyone else could comment on how that's being addressed in the emerging psychedelics markets. And I know that in Oregon, for example, and now in Colorado, the number of these service centers or healing centers, depending on what you call them in each state, ownership is being limited to 5 service centers or healing centers. Is that enough to address this concern of consolidation? What's been done differently in cannabis? What could potentially be done better in psychedelics?
Yeah, I'd love to talk about that. So in California, when we passed Prop 64, there was going to be, it was actually in the law, a limit on the number of licenses or a limit on canopy size. So kind of analogous to what just passed in Colorado. There's going to be a limit on 5. We had a limit in the law in California. And I'm bringing this up because through the process of implementation, that limit was taken away. So, and I think about that today. You know, I'm excited that Colorado passed, and I'm also terrified. And I feel like, oh, it's going to be a replay of a lot of the same things. And I hope very much that people stay deeply engaged in that process, because you can point to things even that are in the actual past initiative that get changed as it goes, as things go through that sausage making process. And that's why I really like thinking about much more meaningful shifts that isn't just trying to address a problem from one area. Okay, so maybe that will help, maybe that will work, but maybe there will also be creative ways to deal with it. So then I call on lawyers. I call on lawyers who are working with clients to be ethical in how they are interacting with their clients and advising clients on the law. We give clients advice. I've been a lawyer since 2005. I'm a founding member of the Psychedelic Bar Association. I do a bunch of other things. I think a lot about lawyers and what we're doing. And, you know, when I was sworn into the California bar, so I'm biracial. I'm half Odawa Anishinaabe and half French American. And the woman who swore me into the bar is a woman named Abby Abenanti, who's a judge. She was the first California Indian to become a judge. She's Yurok. And she read the things that said, all the things you're supposed to say when you get sworn in. And then she also put that aside and said, and remember who you are and where you come from and your responsibility to larger community and to the people, not just you're working with, but to all of life. And, you know, I think about that as, you know, our firm, we are business, corporate, and regulatory attorneys. When we're advising clients in the psychedelics ecosystem, we work with them on ethical business models, on how are they engaging with Indigenous reciprocity and benefit honoring, because it's in all of these different ways that we also have impact on that we are going to see a more healed future for the planet, hopefully, for the psychedelics ecosystem. And I just want to say one final thing, which involves social equity. So, you know, one tool of colonization of the colonizers was they didn't allow Indigenous people to practice our spiritual beliefs. Not until the year I was born, 1978, was that legal. And, you know, I think about that a lot when it comes to, you know, psychedelics. It's such a broad category, right? And, you know, there is a history of an immense amount of abuse with Native people in this country. Both of my grandparents were taken to the boarding schools and couldn't practice their religious beliefs. And, you know, there's a lot there. It's hard for us to talk about because it's such a painful thing. And so, you know, there is a history in this country of treating people, Indigenous people, in a way that, you know, that did involve, you know, different types of psychedelics. And I'm sorry, that's a hard one. And I just really want to bring that forward because I do see, like, I've been exploring this, like, what is that nexus point? And how does this become meaningful for sort of broader, for the broader community? So thanks for asking me that and letting me squeeze in some more.
I want to follow up a little bit on that with a question from the audience, from Eileen Brewer. I mentioned in the introduction just briefly that there's many different approaches that are being taken. There's a very medical approach to psychedelics through the FDA and arguably through some state regulatory programs that are being created. There is more of an adult use or recreational approach. So, and then of course there's the ceremonial and religious, which doesn't seem to be really playing as large a role in these regulatory structures that are being introduced. So Eileen asks, what about at-home ceremonial and recreational use for these substances? When we think about regulations, we can't just think about mental health applications for psychedelics. Framing the regulations around therapy only is stigmatizing already from the start. So any thoughts on that, that comment in question?
I would just say I completely agree with that. And we need to have all of these different points and paradigms of access and meet people where they are. And it needs to be broadly inclusive and cannot just favor sort of a medicalized therapeutic approach. That's not culturally thoughtful. It doesn't work for everyone. And the legacy of these types of lineages have been held sometimes for time immemorial. And we just can't approach this in the same sort of extractivist, okay, now we see this works for these certain things, now we're going to lock it up in business and put it into a licensing system and kind of have it go through those twin engines as we do to commodify so much else.
I might push.
Can I just jump in and add, I think that's such a good question. And one of the things that I think often gets overlooked is that we can't really, we can, but we shouldn't talk about psychedelics as a monolith. I think that there's certain medicines and certain applications that I think it does really make sense to talk about them in a more regulated, more medicalized framework. And then I think there are others where it's completely inappropriate and culturally insensitive, and how we regulate needs to be fine-tuned based on the medicines and the lineages from which they come, or otherwise we risk completely perpetuating a lot of the systems of oppression that these medicines can help us get rid of, actually, to Ariel's point.
Thank you. Rob?
I would just push back a little bit. I don't disagree with anything that's been said, but I think being realistic about what the public would vote for, it's important to do that. And I think, again, kind of taking a page from cannabis law reform, I think there was a reason why it started with medical use rather than broader sort of adult use. And I think that's because the public was much more receptive to that. If you look at polling that's been done on cannabis reform, there's a lot more support, even today, for medical cannabis than for adult use cannabis. And so I think just to get your foot in the door and maybe open the door just a crack, it might take that sort of compromise. It might take a measure that's ostensibly only for therapeutic use. And that can be defined very broadly. Oregon's 109 doesn't limit itself to medical use. It talks about therapeutic, but doesn't say you have to have a doctor involved. But I think that may be a necessary compromise just to get these things passed. And then maybe later on, they can be expanded in the same way that those early medical cannabis law reforms that narrowly passed in a lot of places, but later on they were accepted and states were able to build on them and expand on them.
I'd go even further. I agree with what everybody's saying, I think, and I'd go even further with Oregon and say that it's not even medical, it's almost anti-medical. I mean, if you read the regs, if you're a doctor and you work at one of these places, or a nurse or some other sort of medical professional, you're not even allowed to practice the rights under that license with respect to the service center and the patient who comes in. So you can't say, I think you ought to have this psilocybin because it will help you with your treatment-resistant depression or whatever it is. And if you do something like that, you're going to probably lose your OHA license yourself. So they've really tried to separate it out, and it's confusing because, the measure was brought by psychotherapists and it was sort of sold as like, we have all these mental health problems and, we need new treatments, new approaches. But on the other hand, anybody can just go in and try this stuff. It's recreational in that sense. Mason's really good about always referring to it as supported adult use. What do you need to qualify to go to a service center in Oregon next year? You just need to be 21 years old, really. That's kind of what it is. You don't need to have anxiety or any other sort of generalized or specific health condition. So it's just interesting because like the public messaging is like therapy, therapy, therapy. But what's happening in these places is not that, at least in my opinion, or a different version of that. I know they have an integration session and all this stuff, but it's not that. So those are some thoughts.
What do you all think about that sort of confusing messaging? I think sometimes it's a little bit contradictory. It's my perception that in cannabis, it was pretty clear. There's medical and then there's recreational. Some people accuse the medical of being sort of a Trojan horse for recreational, but from my perspective, it was fairly clearly delineated. Are there risks to this sort of murkier messaging that's being taken by psychedelics, where on one hand, people are promoting it as therapeutic, unclear whether that means medical or something else. Maybe it just means that you benefit in some wellness sense. What are the implications of these differences in messaging and clarity around what the rules are actually achieving?
Well, I'll just say a couple things. You know, it's so interesting, these concepts. Like, some would say all use of psychedelics is medical use. Indigenous people, the ceremonies that I sit in, we call it medicine. Some people would say it's all religious use, you know? So these are kind of imperfect categories and interesting to think about. But when it comes to passing laws, you know, I've also been involved in passing initiatives. And how do you frame things? How do you get the voters to vote for them? How do you, you know, what feels safe and digestible? The concern about doing that is when we present things in a certain way to the public, to the regulators, I mean, my experience in Oregon, much less than what you've had, certainly Mason and Hadass, is, you know, the regulators seem to interpret that the law as largely therapeutic and somewhat of a medicalized model. You know, their unwillingness to incorporate the entheogenic practitioners framework and really head on address the expense and accessibility issues in the law, you know, showcases, I think, what can hamstring us if we promise, if we present a certain thing, if we describe things in a certain way, and then maybe the regulators, and during the implementation process, they feel limited by that. You know, it has been the spiritual, religious legacy, you know, practitioners that have brought psychedelics and held these traditions and worked with communities and peoples in these settings up to this point. And so I get nervous about sort of the frame that we put on when we want to pass a thing and talk to the public in a certain way about what that means on the other side.
I want to flag.
I think it's a delicate line that we walk, because on the one hand, we want this to pass. We want to get people access to these medicines, and we don't want to pass laws that we're going to have to go back and correct as a general rule. And, you know, again, just to my point earlier about each drug has a different risk profile. And I think it's really important that we're not lumping things together. For example, you know, when we're talking about 109 in Oregon, psilocybin has a very low risk of toxicity and a very low potential for dependence or addiction. Adverse events are like getting a headache or getting nauseous. And so I think psilocybin in a wellness paradigm, in a ceremonial use paradigm, especially given its lineages and the people who have carried it, I think makes a lot of sense. I think on the other end of the spectrum, you have something like ibogaine, which has a super complex pharmacology and can be neurotoxic and has a propensity to cause cardiac arrhythmias, and it can make your heart stop beating. It can kill you. Ibogaine for addiction treatment requires another level of regulation. It is a plant medicine that has an indigenous people's lineage, and that makes it a little bit more complicated. But should we be thinking about, is it useful to think about it in the same lane that we're thinking about psilocybin? I don't think so. I think those are really separate conversations, and I think we owe that kind of care to these medicines and to their regulation and to the people who can safely benefit from them. I think when we're talking about like these very closely regulated frameworks, I think ketamine is a good example of something where like I don't have a concern about the cultural implications of overly regulating ketamine, right? It's like a super beneficial and cost-effective drug that interacts with your opioid and dopamine receptors, and obviously does have the potential for addiction when it's not closely monitored. And people are afraid to talk about this problem because they're afraid that the solution is going to be prohibition or criminalization or over-regulation, but it's not. The solution is just smart regulation. And, you know, right now we don't have a national prescription monitoring system for ketamine. Why? Why would we do that? We know unmonitored ketamine use is problematic for patients. Dr. John Crystal, who actually on Tim Ferriss's pod was just talking about that, you know, when people were given ketamine for home use and instructed to take it whenever they needed to maintain their own equilibrium. Some people would take it once a day. Some people would take it 5 times a day. 5 times a day, that kind of compulsive use, frequent high doses, you know, instead of lower sporadic doses, it makes patients even more susceptible to depression, and it can cause addiction. And there's no regulations, there's no infrastructure for that, from stopping patients from getting ketamine for 5 different telehealth clinics at once. They can get it delivered to their homes from their phones, and they do, and they'll keep doing it. So this is a situation where I actually think it's completely appropriate to understand everything we're doing within the medical framework, because ketamine is effective, and there's a way to regulate it that will allow people to have access to it. We just can't be shy about calling out the risks and regulating for them.
I want to zoom in a little bit on some of the Oregon system, because we have some great audience questions about that. But first, I actually want to zoom out and kind of look at the federal structure here, and I want to ask Rob, since you're arguably probably the foremost expert on federalism and cannabis, what are some of the limits here on what states can do with psychedelics law? We're seeing all this state regulation emerging. Of course, psychedelics, most of them remain Schedule I controlled substances on the federal level, so they're highly restricted. What can states really do given the limits of federalism? You're muted, Rob, sorry.
Sorry about that. It's a great question, and let me give maybe a couple of examples to illustrate some of the more poignant limitations. So one of them, and I heard mentioned before, it's the idea of, what if we just had a state-owned and operated psychedelics industry to deal with some of the concerns about commercialization? States did that for at least alcohol distribution. We still have some states that run all of the alcohol stores to try to assuage the concerns that you'll get a for-profit operator coming in there and pushing too much of the stuff on the public. I think that's just not viable with psychedelics, and it hasn't happened notably for cannabis, even though there are lots of good arguments to have state-run cannabis stores. We really just haven't seen that. And part of the concern there is a preemption concern. That if a state sets up a state-operated store, someone might come in, wage a legal challenge against that, and get it shut down. Even if the DOJ isn't prosecuting, you still have that legal vulnerability. The other problem states might run into, and again, this depends on how the federal government responds, it's in the collection of all the data. I know states are interested in that, and there's a lot of value to data, keeping track of who's producing psychedelics, who's distributing them, who these facilitators are they fully trained, who's using it, is it helpful for them? As a public health scholar, you can imagine how helpful all of that information might be. But again, as I alluded to in my intro comments, collecting all that data poses a risk. And in the early days of state cannabis reforms, a lot of medical cannabis states run medical cannabis registries where they have very detailed information on every single person in the state who's authorized to possess and use medical cannabis, as well as who recommended it to them and where they're getting it. And the federal government, in a couple of notable cases in Michigan and Oregon, went after that data to try to help with federal prosecutions of state-regulated cannabis suppliers. And that actually caused another state, Maine, to abandon its medical cannabis registry. Just said it's not worth posing this risk to our patients, exposing them or their suppliers. So I think that's another area where the states have to be careful about how they regulate the industry. Are they creating choke points that the federal government can shut down? Are they generating data that the federal government might grab and then use against participants in this industry? Some states are willing to do it, but it discourages other states from doing so. So those are a couple examples of limits that the federal government and the ongoing federal prohibition might impose on states operating in this field.
Ariel, did you want to comment? What about federal regulatory changes in terms of psychedelics? We've seen for many years great resistance to changing the status of cannabis, although the Biden administration seems poised to do something, not exactly clear what, potentially discussing changing the scheduling status of cannabis. What are the odds that we'll see any changes on the federal level for psychedelics? Someone mentioned there's a lot more interest in their medical use and commercialization than there has been in cannabis. How does that change the potential? What do you see on the horizon for federal regulation?
I'd be surprised if it changed a lot anytime soon. I think there are a lot of reasons for that. One is a legal reason. The federal government feels constrained by international treaties it has signed with respect to scheduling these substances. You'll see even with cannabis, that's often cited as a reason why it can't move. And when a drug is approved, like with Epidiolex or whatever it is, they're forced to schedule it maybe on 5 or something low, but they feel like they can't just broadly deschedule or reschedule, maybe reschedule some of these drugs. And I just feel like, people have been trying to do this stuff for so long with cannabis and it never goes anywhere. And psychedelics are further behind. And I just don't see it happening anytime soon. And I've been burned in the past by predicting cannabis will be rescheduled by 2020. I found like old embarrassing remarks of those by mine. So I'm always hesitant to like get out over my skis on this stuff. That's just my thought.
Could I just add one thing? I wonder though, because, there are statistics like 17 to 22 veterans kill themselves every day. And people high up in military and in government, are seeing that ayahuasca and MDMA and psilocybin, are so helpful with PTSD and other difficulties that I wonder if, I just wonder about that, but I agree with you. it's like we're in such a different time. 380 people die a day in this country because of drug and alcohol related deaths, like we're in such a health crisis on so many levels. You just hope there will, like with big problems, we need to approach with big creative solutions.
I think that's such a good point. I think that a lot of the work that that medicalization at the federal level is doing right now, what it's going to result in is one question. What if the work it's doing right now that I think is useful for all of us is it's normalizing the discourse around the utility of psychedelics, period. And that has impacts now. And I think, one of the things that that psychedelics did learn from cannabis is that there are serious consequences that result from withholding these medicines from people who need them, like people who are suffering right now. And we need to make sure that we do everything in our power to expand access to anyone who can safely benefit. And sometimes that is sometimes those are practical moves on the chessboard, and sometimes that's a communication strategy, and sometimes those look like the exact same thing, even when they're not. It's something like 45 people a day in this country are dying from opiate overdoses, 125 people a day committing suicide. I think we have to try all of the different ways and see how they work together to create change overall.
I want to zoom in a little bit on Oregon and Colorado. We had a couple questions about the training requirements for psychedelic facilitators. Anjana asks, do any of the panelists know the requirements or criteria to become a facilitator under the Oregon and Colorado models? Will the requirements themselves be cost prohibitive? And then Noah asked a related question about a potential glut of, an excess of facilitators that cannot find jobs. There are a lot of training programs opening in Oregon. We don't really know how many service centers there will be to employ those facilitators. Do the training programs have an obligation to counsel and sort of warn their trainees that this is an unknown, unexplored market and their job prospects are unknown?
I could take a whack at it just from being here in Oregon and having read those rules and thought about them. So the service centers have to be accredited by the states. Those are the places, I guess, that train the facilitators, and they're required to train them in various modules. There's a series of modules, and there's a certain total hours requirement. Maybe, I don't know what it is offhand, Mason, do you know? It's like 120 hours or something like that.
Yeah, 120 classroom, and then I believe
Okay.
it's 40 or 60 practical. Can't remember.
Yeah. Okay. Yes, there's a practicum requirement. That's right. And there are a lot of big questions in there, like $1 million questions. I don't know, like, if all those people are going to get jobs or how many service centers there are going to be. Nobody knows. My general gut on it is the program's going to be cottage and not as big as one might anticipate, and there won't be as many applicants as we saw initially, say with the cannabis regulation measures, the adult use cannabis stuff. But we'd be sheerly speculating to try to answer questions like that. So all we can really tell you about is like the training requirements, what you're allowed to do as a facilitator, and watch out for heavy tax burden of under Section 280 of the Internal Revenue Code. There's going to be a lot of shifting and gamesmanship as between the service centers and the facilitators as to who has to bear the brunt of that. And I also think an interesting dynamic for facilitators is going to be whether they really kind of dictate terms to service centers or vice versa. I haven't heard people talking a lot about that, but I have almost a feeling that if you're a sought after or popular facilitator, maybe you will be able to dictate terms quite a bit to the service center. If you have a lot of people that want to sit with you and have you kind of go through their psilocybin sessions with them and you control all of those potential clients, maybe you'll be able to, dictate terms to the service center. So I think that facilitators that are more entrepreneurial may end up doing a little bit better. At least that's my initial thought reading through the rules and seeing how this stuff is set up.
I have a very legal question from Dan McKillop about the dormant commerce clause or interstate commerce issues. What are some of the relevant issues there in terms of psychedelics? These have come up in the cannabis space.
Hey, Dan, I should defer to Rob, other than to say that we have a residency requirement in Oregon, which I think is illegal under the DCC. Go ahead, Rob.
Yeah, that's right. I've actually been working on these for the last couple of years. I think this is a big issue that caught a lot of states off guard. The Dormant Commerce Clause basically says you can't discriminate against outsiders. You can't prevent non-residents from owning local businesses or even from shipping in product from out of state. In the cannabis realm, states just assumed, hey, this doesn't apply because the federal government has banned all commerce in this. But now there are several court rulings that say that assumption is incorrect. Dormant Commerce Clause applies. I think they're correct. And if it applies to cannabis, I think it's going to apply to psychedelics as well. And that means, as Vincent said, you can't, as a state, say, hey, only locals can own these service centers or psychedelics production facilities and so on. You've got to let outsiders in. May also mean that you've got to allow the importation of psychedelics from other states, which could have ramifications on consolidation in the industry and so on. So it's a really big issue. cannabis reformers and cannabis regulators are just now coming to terms with it. So I think it's a good one for psychedelics reformers to learn from that and figure out what's happening in cannabis and preemptively address it now rather than trying to clean up the mess later on.
To sort of bring it back full circle too to what Ariel and Mason were talking about earlier, I think one reason ballot measure writers and regulators like things that may violate the Dormant Commerce Clause, meaning residency requirements, is that it's a way to keep programs small and to try to fend off consolidation ultimately, right? Mason said, well, you can only own up to 5 service centers. The other thing that really limits consolidation is saying only residents can own these things, right? It's a way to keep like a lot of big money out of the state. And I don't know if that'll actually work. I don't, like when Oregon opened up to non-residents, it was the first state to do that for cannabis. And they were the first jurisdiction in the world that said, you can be from out of state, you can be from California and invest, you can be from Nevada, you can be from Mars, we don't care. And I remember getting calls from people all over the world at that time trying to invest in these companies. And the big fear was, oh my God, it's going to consolidate into a couple of monoliths. It didn't play out that way. And so I'm interested to understand how effective that tool actually is for regulators versus the risk of dormant Commerce Clause requirement. And I think what the drafters did in 109, which is smart, is say it sunsets in 2 years. So by the time somebody challenges, it might be mooted anyway. And I don't think there's gonna be big litigation around it. That's where I see it going.
Interesting that the training programs are not subject to that requirement, so they can be anywhere in the world, arguably. And training programs also are the only entity in this industry that doesn't pay a license fee to support the administration of the program, whereas the licensing fees for these other businesses are shaping up to be very high, on the $5,000 to $10,000 range per year. We are running out of time. I want to give everyone an opportunity to make a final remark. What do you think is most important that could be learned from the cannabis industry? What would you tell the psychedelic legislators or people drafting these psychedelic laws, or anything else you'd like to comment on?
Maybe I'll take a first stab at it. I would start pushing the Biden administration, not for rescheduling, because we've discussed that's tough, but maybe as a compromise to come up with something akin to the Ogden memo or the Cole memo that was used for cannabis. I think that was very effective at sort of allowing states to craft new regulations and new ways of regulating cannabis, both medical and adult use. And it would just make things at least a little bit simpler for state regulators, give them a freer hand. So I would push very hard for the Biden administration to take that small step. I think it's politically palatable. I think there are good public health reasons for it. And it might be a stopgap solution until some bigger legislation might come out of Congress or bigger scheduling action.
I'll plug your article, Illinois Law Review, right? On that, you have an article on that?
Yes, that's right. We need a Cole memoranda for magic mushrooms, I think was the title they chose.
Excellent. Check that out, everyone. Other concluding thoughts?
My big takeaway for people in the industry is you're probably held to a higher standard, and it's not fair. And you're kind of an ambassador because you're early, and you have to be careful and you have to be reasonable. Think, for example, about a psilocybin service center. If somebody leaves that center and is injured or gets in a crash, that's going to be a really big deal early on in Oregon. And there's going to be all sorts of people clamoring, okay, look at this, look at that, shut it down, look what happened. It's not the case with the bar, right? People are overserved and cause crashes all the time. And nobody talks about shutting down all the bars in the state. I think people have to be ready for that kind of environment and those kind of conversations early. And I think if you're working with people in the industry, lawyers, for example, you're held to a higher standard too. Your documents should be really good. Your advice should be cautious, right? Understanding what these businesses are doing. And I just think that's just part of being in and around that stuff.
There's so much I want to say. I hope we think about conservation issues and the environmental impacts that flow forth from, you know, all of our actions over these next years. I just think about all the plastics that are created in cannabis. But what I want to say is, you know, we're talking about training of therapists and facilitators. I wonder if we could spend as much time thinking about how companies and businesses could also operate in an ethical fashion. If we spent almost as much time really thinking about that and implementing that into laws, if we're gonna license businesses and go a similar route. So that's sort of my curiosity, is ethical businesses. How do we do that?
Hadass, you want to take us home?
Sure. So I just want to make a plug for harm reduction, which is a set of strategies and ideas aimed at reducing the negative consequences that are associated with drug use, because they exist. And earlier I mentioned ibogaine and how dangerous it is, and it is. But a lot of people really need ibogaine to save themselves from something even more dangerous. And you know, we need to understand the risks associated with all of these drugs, these medicines, whatever you want to call them, and make them as safe as possible. But I don't think we can afford to wait around for something that has no risk, as if such a thing even exists, or for the perfect system. I think we've got to be rigorous with data and with the creation of regulation and safety and protocols and screening and dosing. But we've got to, I want to impress somewhat of a sense of urgency upon all of us. And I think that there's a balance, and I think that we can strike it. And I don't think that we should prioritize, you know, getting this over the finish line at the expense of entire groups of people, cultures, of lineages. I think we just need to be really thoughtful and really, really focused, because we are losing people every single day. But the way that we do this, the process, is also very important.
Thank you so much for those outstanding closing thoughts and for your participation. Thanks to all of our attendees. Thanks again to the staff of the Petrie-Flom Center. I hope you have a great rest of your week, and thanks so much for joining us. Take care.